Okay, recording
This meeting is being recorded.
and starting the webinar.
Have you opened the webinar? Because I have somebody
Yes.
trying to get in who said that it said that the webinar wasn't open yet. Something like,
No, we've started.
Oh, there we
We've
go.
started and the attendees are rolling in. Yes.
Oh,
I
good,
see
good,
we
good.
are
Okay,
on
there we go.
51
Alright.
now, yeah.
Oh, great. Sure.
Okay, Glenn, Nicole, shall we just start? It is 10:03. There's about 60 people in the already on the online, so we can commence, all right?
Yeah,
Okay.
we're good to go.
All right, good morning, folks. It's a beautiful morning here in Cape Town. Unfortunately, due to load shedding, some of us are working from home and others are working from the office, but nevertheless, we are here to convene this very important session today. Today, of course, is the second open session to the nonprofit sector. And what we're going to be talking about here is the discussion will be around the Nonprofit Organization Act, the amendment that is being proposed by the Department of Social Development. And I bid you a very, very warm welcome and buckle up, sit tight. It's going to be 2 hours of interesting discussions and sharing of information. So, just going to give me a chance to, okay. So, of course, we would like to talk to you about housekeeping. This is a webinar and all of you are muted upon entry. Unfortunately, you won't be able to unmute yourself. If you have a question, if you could please just post it in the chat. We have also assigned one of our colleagues, Jocelyn, in the event that some of you have a problem communicating to us via the Q&A. You're welcome to send her an email and she will park those questions and we will attend to those questions in the Q&A session. When I show you the program, you'll see where that fits in just a little bit later on in the morning. And then, of course, you may have heard when you joined that this webinar is going to be recorded and we will share, as we have done so, with all the information and the recordings up until now, since October 21st, when it was actually the first time we met back then. I can't believe how the time has flown. And then, of course, Glenn will talk to you about the process since October the 21st, so I won't cut in on his space. So that's us in terms of housekeeping. I also upfront want to thank the working group who has played such a profound role in moving the discussions forward since October the 21st. And I think you have all been shared the communiques, the various communiques around that so that you're up to speed. So I'm going to hand over now to, well, let me quickly take you through the program, sorry. So that's the program. We started a little bit late, I'm sorry. Glenn will be giving you the overview and the feedback, and our dear Nicole Copley will take you through some of the submissions that she's been very, very kindly gathered over the last little while. William Bird will join us around 11:10 to talk to you about registration of NPO, some of the work that he's done in the background. And then Suzanne will just take us through a proposed nomination process that we would have to discuss with you around the meeting that is going to be coming up sometime in March with DSD. And then we're going to go through a Q&A session and then we'll close. And we're aiming to finish around 5 to 12-ish. So yeah, over to you, Glenn. Glenn,
Thanks,
yeah.
Video. Sorry, just unmuting. And good day to everyone. Thank you again to Inyatelo for coordinating us as usual. using all the resources at their disposal to assist us as nonprofits to engage in a critical area. I want to firstly just acknowledge that I'm the third choice person to give you this background. It was originally going to be Nazima from Inyatelo, who I think everybody knows. And then unfortunately, she had circumstances which required her not to be able to be here today. And we do send our best wishes at this time. And then my colleague, Boichoko Detlake, who I think many of you are also familiar with, was also waylaid and could not attend. So I'm going to therefore try and substitute for people which I am obviously not as good as. So please stay with me. Colleagues, so I want to start with by saying I can't think of another piece of legislation that has been a hostage of fate as much as the NPO Act. And I'll explain briefly what I mean. Way back when, for those of us who are going gray, prior to 1994, there was an interesting process that occurred in South Africa. And it involved a number of stakeholders across the spectrum: academics, NGOs, think tanks, community-based organizations, and the then African National Congress, to create a vision for South Africa beyond simple legislation and constitution making. And that vision was a compact, a social compact, which became the Reconstruction and Development Program. In those interactions, which laid the foundation, were intended to lay the foundation for our democratic state and its interaction with civil society at large, in meeting the social and developmental challenges left by apartheid, one of the key presumptions was that we were going to need strong NGOs. We were going to need a vibrant civil society, and the state was going to have to create an enabling environment for the sector. That background is how we ended up with the Nonprofit Organizations Act. And I think on reflection, many of us came to realize that embedded in that legislation was what we came to call the killer assumption. And the killer assumption was that we had all agreed to the social compact, and we were socializing, not only through the state, not only in the private sector, not only in the NGO sector, not only with trade unions, but across society. We were socializing this common developmental agenda to move our society out of poverty and to enhance the dignity of all our people. This legislation then became a hostage of fate, because no sooner had the NPO Act been legislated that the entire framework on which it was premised shifted significantly at a macro level. And it took us a little while to catch up to the realization that the assumptions are embedded in the legislation and also its practical implementation was not fit for purpose. It did take us a while. We're slow, but we got there eventually. So for, I think, more than 10 years, we've been grappling with where do we go with this legislation? Where and how do we create a new architecture that is fit for purpose today and in the future? And the conflictual relationship, which has come to dominate how civil society and NGOs interact with government, has predominated a lot of our suspicion of each other. So when in 2018, the Department of Social Development, which is the line ministry responsible for this legislation and its implementation, issued a memo, it was not the first attempt to get something over the line which could be workable and acceptable to all stakeholders. Some of you would recall that between 2012 and 2014, there was a draft NPO policy which never saw the light of day. It got stuck somewhere, largely because I suppose it didn't meet the requirements of the sector, and it certainly seemed to be a case of overreach on the department in terms of its regulatory mandate. So this friction that exists, I think, is one of the key things that the working group and others have been attempting to iron out and turn into a constructive dialogue between the departments. So as Fidel has already said, in October 2021, there was an open session and the discussions began. We must just note that minor amendments were made to this act in the year 2000, but they were really of the most administrative kind. So at the moment, the preamble to the bill states that the intention is to amend the NPO Act of 1997 and insert certain definitions to provide for the office of the Registrar of Non-Profit Organizations, to provide for the registration of non-profit organizations and the compulsory registration of foreign organizations, to provide for the arbitration tribunal for the dispute resolution, and to provide for matters connected. So the grammar isn't mine, it's the department's. So that's really where we have been vexed. Now, public comments were intended to be made, and those deadlines have been shifted. We have had various interactions amongst ourselves and with DSD, the summary of which, if I could just share with you at this point, is that DSD and interested parties, oh, by the way, all of the information on the background can be found on the Inyatelo website. In the invite that was sent to you for this meeting, you will find the links, the hyperlinks to take you there if you want to go through it forensically. But for the purposes of now, we can record here that in 2021, that is in November of last year, DSD and the interested parties will work together on critical processes affecting the sector. And it's acknowledged that the sector is diverse and has many components. It's also a point for discussion for ourselves that I think we need to note that given the diversity of the NPO sector, the aim here is not to make sure that we are homogeneous or completely saying the same things, but to facilitate a broad spectrum of opinion, but in some cohesive way. One of the issues which all of you know when you engage with government departments at whatever level, there is a tendency for the sector, NGOs in particular, to be referred to as disorganized civil society, or sometimes disorganized uncivil society. Our incivility, however, is not really that valid, because we know that government, while it keeps on pointing fingers at NGOs, does very little to facilitate cohesion and coordination amongst the sector, and in fact, in many ways, fosters competition and chooses and plays favorites in its work. Now, this is something that as this audience, we want to acknowledge that we have different points of view. We want to acknowledge that we are not the same, but that we can at least engage and be constructive in how we input into processes that will affect us all. So while we are allowing everybody's voice to be heard, we do think that at the end of that, there may be consensus around which we can cohere, but also as we go through the process, it is better that we are coordinated than not. Colleagues, so at this point, DSD has been compiling what we are faced with is DSD's attempt to explain its actions, its amendments as set out. There was a memorandum that supported which was supposed to be taken to cabinet around the draft NPO bill, but this remains unclear. The department insists that the amendments that it is making are of an administrative nature, and therefore, quite literally, it's no big deal. Also, that these amendments are intended to address certain administrative concerns which limit the capacity of the department. So the department points to what they feel is an urgent reality that the NPO directorate in Pretoria is unable to fulfill its tasks. And so it needs these amendments so that they can facilitate greater access and efficiencies. We are going to, in the next few days, in March, there will be, as you see also in the invite, to please register for the event, where the department will present to us the logic of its amendments and engage with us with regards to the submissions that have been made thus far. Beyond that, there is a recognition and acceptance on the part of the department that the NGO policy process needs to be put back on the table. And this will also form part of that conversation and interaction. So here today, colleagues, we have made significant progress. We have been able to engage with the department. From our understanding, they have chosen not to go to cabinet on these things, but they have requested the extensions. So the process of making submissions is ongoing, and we accept that that will continue. We will have an interaction further with the department, and I think the purpose of this meeting is to bring ourselves up to steam and make sure that we're all on the same page, as I mix and torture my metaphors, so that in that consultation, we can have the optimal outcome. It won't be perfect. We are going to have to engage with the department and understand its thinking. But from our side, I think as those who have been in the working group, our understanding is, one, we need to consolidate our inputs and need to understand these issues which critically affect us. Two, we need to make some strategic choices about how we actually view this amendment process in relation to what is necessary. If the process is unfit for purpose, if it is going to be creating more problems down the line, then how do we engage with it? And I think lastly, it's about how within all of these discussions, beyond the legislation, do we address the burning issues that confront the NPO sector through advancing a better overall framework for the non-profit sector. Fidel, with that, I would like to welcome everybody again, and I look forward to our interaction on these critical issues.
Thanks. Thank you very much, Glenn. I think Glenn has certainly painted a really good picture from what happened since the October 21st meeting. He's provided good context. He's also provided us with some of the progress in the attempts to engage with the department, and that's been really good. But there is much more work that needs to be done in order for us to reach a favorable outcome for the sector with regards to this very topical issue at the moment. And so our next speaker is Nicole Copley. And I'm going to hand over to Nicole. You are going to, I'll stop sharing and you will then share your presentation. Thanks, Nicole. Over to you.
Thanks, Farrell. Perfect. Let me just hello, everybody. I can't see you all, but I've been chatting to some of you. Thanks so much, Glenn, for that fabulous introduction. Very concise and yet accurate in terms of a really long history we've got going here. So I'm sorry, that's just the first page. I'll explain to you now where we're going. I'm in the room as a lawyer who's worked in the sector for a long time and seen various iterations, as has Glenn and many of you, I'm sure, of drafts and policies and bills and things going past us. I just want to see my clients and the sector as a whole actually supported and enabled by the legislation. And as you all know, the NPO database is losing credibility hand over fist every day. And I'm more and more seeing new startups and old organizations coming back to me saying, this NPO thing's not worth anything. Why bother? So there's a weariness that's set in. And I think we all know it's because this database hasn't been cleaned up and tidied for 9+ years. There's been lack of political will to do it. So it's all meshed together. But I still believe, as did the people who were behind this whole thing from the start, and all of us, I think, who are in the room, that set right and set straight and with all the details in line, this piece of legislation has an ability to actually enable and empower and support. Anyway, so here we go. I'm going to go through in some, I'll try not to make it too much detail and too much boring detail. And I think I'm going to be relying on whoever's in charge of the chat to alert us to when I need to slow down and go back on something. And so send up a flare. Is it Suzanne who's running it, whoever's running the chat? What we did was there was a closing date for submissions, an initial closing date for submissions, and DSD accepted, got a whole lot of submissions in. We discovered a couple of weeks ago when we asked them that they didn't appear to know how many submissions they had offhand, and they hadn't really interrogated them or looked at them at all. So, and just so that we could enable everybody to have a look at these things, we have at our offices at NGO Law taken all of the submissions and we put them onto a big old Excel spreadsheet. And today, and we've done a bit of refinement, and those of you who are in the room, you should have been sent this updated version, which adds in some colors and groups things and summarizes things so that hopefully we can have a useful discussion without wrangling with the whole clumsy mess of it at all. So those of you who haven't yet received that, who want to receive it, I think Suzanne's the one who's going to send it to you from Inyatello. She's got it and can forward that to you, but I'm just going to talk you through it. This front page is just a summary. So there were 35 numbers of amendments proposed. 15, the DSD actually sent to us, we offered to do this collation and summary for them. They said, yes, please. They sent us all of the submissions. There were in fact only 15 substantive submissions or coherent submissions made. And there were a couple of the amendments that had no comments next to them by anybody. So that's 10 of them. So we're looking at 25 individual line items, if you know what I mean, that are on that spreadsheet that we then have had a look at. So just this little graph, if you can all see it, just gives you an idea. And we've kind of used colors to show, do we agree, do we disagree, that kind of thing. And that's just in terms of the various clauses, which of course is not very useful, but a graph's always fun. This is the big summary which we've prepared, which goes through, and I'm not going to use the screen much because you can see it's quite hard to see. It just goes through every single little, it talks about the amendment and refers to the clause and the numbers of submissions and then summarizes the suggestions being made. Then we took that summary and we colorized it. So you'll see here, I don't know if you can see these colors. So we put green next to the ones that everybody seemed to like. And right at the other end, the dark orange is the things that everybody was up in arms about and said, over my dead body will this go through. And then there's a range in between. We kind of think we like it, but this needs tweaking, some clarification. We don't understand what you're talking about. This needs amending. The gray is, okay, there's a lot of back and forth and nobody's sure. Majority disagree, majority oppose and suggest, majority reject. So it's those kind of use that kind of thing. So that's the whole lot. And then if I can just, we can go through and we've classified them by pulling out first the things which are kind of technical, legally amendments. And just as long as it's just to tell you that we haven't judged or omitted or done anything with that. We've just pulled it all in and summarized it all as best we can in terms of our understanding of the submissions made. If you've made one of the submissions and we've mis-summarized it, please let us know if we haven't understood. But I think we've got it into a workable state. And so just in terms of the technical things, so some people were asking for clarity. The only one I really want to talk about, and it's just because I've got a personal interest as a lawyer in this one, and that is that I feel that the reference in the Act to founding documents as being a constitution creates an ongoing legal confusion in everybody in the sector who think that because you've got an NPO number, you have to have a constitution. Of course, only voluntary associations need those. So that was something that came out of my corner and the corner of the other legal professionals and accounting professionals who made a concerted submission on that. So then if we can just go, now these ones that we've collected together were what Glenn was referring to in terms of the positioning. And so this is these clauses we think are, and we say we think because we think that that's what's behind some of them, because if you read the bill itself, it's sometimes quite hard to interrogate and to see what's behind the proposed amendments, but this is the best we can do. So these are really definitions, and it's around a naming thing and around the bill proposing that instead of being that it's a registrar of nonprofit companies instead of a director and a directorate. And I'm not going to comment on it. There are various opinions in the sector around whether this is useful, significant. Certainly, the people in the offices of the NPO Directorate think that this renaming will enable them to access greater funding and be in a different context, perhaps. And so that's a kind of a political thing. Please, if anybody has anything that they want to flash up on this or insights, put it in the chat. Because I'm presenting my screen, I can only see a couple of you. So I don't know if somebody wants to send me a note if there's something I need to stop on. Suzanne, maybe what I'll do is just keep my WhatsApp open. So maybe just send me on WhatsApp. That'll be a good idea. Okay. All right. So that's the structural.
Sorry, Nicole.
Yes. Thanks, Beryl. Thank you.
If I may comment, what we decided to do was to take all of those questions right at the end.
Okay.
So that we can get through. Is it okay with you, or would you prefer to take it as it comes?
I actually think that because we've classified it like this, I think it would be useful if there's a question and a comment that we would have.
Okay.
Okay.
Sure.
And I'm just getting a note to say that I need to make my screen a bit big, my text a bit bigger here. Sorry, I'm just going to zoom it so people can read it a bit better. Please just send me a note if that's all right. Okay, is that a bit better? Can everybody read that? Sorry. So if there are any questions or comments on this part, Carol, you didn't have anything to add, or Glenn, on this aspect here in terms of the naming. Have I summarized it correctly?
Yeah, no, I have nothing to add.
Okay, all right. Okay, gone. All right. Anybody else anything to add? Thanks. Okay, then this next category is a little bit, I think wave your hands if you can't read the writing. Is the writing big enough? I'm actually looking across the office. Somebody in my office is dialed in as a viewer, and I've got to zoom it up more. Let me just do that, please. Sorry. It might mean I have to scroll back and forth so you can see it all. Okay. Is that better? Okay, I'm on 150. Okay, so these are, and we'll just let the colors maybe speak for themselves. Let me scroll to the right quickly so you can just get a recap of what those colors mean. So it's the green, red, yellow, all the way to the dark orange. And then these I'll just go through briefly. So one of the things that you'll see crops up a couple of times is this compulsory registration for foreign organizations. And there is a lot of debate around it, and a lot of understanding, perhaps misunderstanding around it. Certainly the way it's been phrased in the Act, it's unclear what they're about or what they're intending or what mischief they're trying to stop. And then the other thing I'd just like to note is that it seemed to us in our initial consultations with the NPO Directorate that they didn't have the background in terms of there already being legal requirements in terms of the Companies Act that anybody who's operating in South Africa as a foreign nonprofit in any other way other than just giving out money actually does have to register, and they have to register with CIPC, and then they're inside the legal system and inside our tax system and everything like that. So my personal feeling is that these clauses in terms of foreign organizations registering are not required, because the mischief that they were seeking to deal with actually is already dealt with by the legislation. But if there's anybody who has another view on that, please let us know on that. I'm just going to go to the ones that are kind of darker in hue, and you can see, for instance, so this one, there were 3 submissions, and then we've summarized kind of what people said and other people. So one party said, okay, we like this, and another of the submitters said these things are not defined. So there are always technical things tucked inside of them too. Okay, this prevention of similar or identical names being registered on the NPO database, this is something the storm erupted over. When I say something the storm, 7 of the 15 people who made submissions about it. And as you can see, 5 of the submissions that were made on this opposed it. And I think that there was, when you look at and if you go to the full text of all of the submissions, you'll see that a whole lot of this is around actually. So at the moment on the NPO database, there are a lot of nonprofits registered with the identical names. And there are various views on it. And some people think the law must take its course and that there's common law around it. And certainly the directorate doesn't at the moment, or their technical systems don't at the moment have the kind of technical capacities to be able to do checking and filtering. And there's also no integration with other systems like SARS systems and Companies Act systems and masters of the High Court systems to be able to cross-check for similar or identical names. My personal view on it, and if other hands go up and give their, please don't let my personal views dominate. But I just can see that in terms of the application process, if the technical stuff is not smoothly running and right and working, it's just going to create a huge backlog in terms of actual applications. It's going to become a major sticking point for new people trying to get into the system. If it isn't kind of an electronic checking process, and if that isn't smoothed out, my feeling is that, given that I don't think they can get that right soon, I suspect this thing needs to be laid down until they've sorted out the technicalities. And I think that most people tend to agree on that. The other one, which is dark orange here. Okay, so this one is I think that there's a mistake in the drafting here. So in another part of the amendments, they were intentionally talking about mandatory compulsory registrations for foreign nonprofits. And to just give you the background, when the Nonprofit Act was first introduced and replaced the old Fundraising Act, it was, in my recollection, an important component that it was a voluntary registration, that there would be credibility and accountability and transparency that would be given with being able to be accepted onto the database, and that this would attract the right sort of organizations and that they would then be conferred with that status. But it wouldn't be like the old Fundraising Act where you weren't allowed to collect a cent on a corner unless somebody had approved you from the fundraising directorate, which it was then. So in this particular amendment, though, they refer to mandatory registration for any nonprofit, including a foreign nonprofit. You can see 9 people who submitted noticed this, and the consensus was that they must have made a mistake here, surely, because this if they had intended it, and they can't have, because there are other places in the bill and in the Act, in fact, which aren't amended, which talk about it being a voluntary process. I just think that that was an error, but certainly that has to be fixed. Then in terms of the application for registration, there is, at the moment in the bill, it says you've got to submit 2 copies. The amendment being made, I think, is taking cognizance of the fact that we're in an electronic age. Most of the applications that are being made online. So the idea of having to submit 2 copies is not required anymore. And even if physical applications are still being made, those documents will be being scanned and put into a physical, into an electronic database. So some of the comments that came in maybe didn't have that in mind. And then there were other suggestions around perhaps delays in registration and arbitration tribunals. But so as you see, there's kind of, with every clause, there are technical things, and then there are things that give rise to other things that come out of it. This particular one, which is in sort of pink, is quite a fundamental change, really. And this is the thing with amendments and bills, is sometimes the things that look the most lightweight aren't actually, and it talks about reporting, and in doing so, and the act used to talk about the accounting standards that were required for reporting, and they've now dialed that back and put in more generic terminology and said around accounting and around other sort of things, they've added this word in the prescribed manner. Apparently the intention behind this, and this is from previous engagements and from my own conversations with them, with the directorate, is that they're looking at introducing something which I think the sector on a whole is behind, and that is, like there is in the Companies Act, there being strata of compliance or different layers of compliance requirements that are adjusted according to the size and the turnover and the ability and whatever of the particular nonprofit. So instead of having a one-size-fits-all compliance standards, which some organizations may be shooting over, but a whole lot of organizations actually aren't able to do that because they don't have the funds or the whatever capacity to do it, that they instead want to introduce layers of various strata depending on various things. But instead of going out and putting those out up front, they've instead dialed it back and said in the prescribed, in other words, because they want to be able to issue regulation from time to time, I think saying in these kinds of layers with these kinds of turnovers, these will be the prescribed requirements for this and for this and for this. I don't know that I'm explaining that properly. If anybody needs me to go through that. I think there were counting firms who said that they must stick to the high standards in their submissions, if you look at the submissions. Yeah, so any questions on that, please do let me know. I think I'm just going to these kinds of a narrative of activities within 9 months.
Sorry, Nicole.
Sorry,
I
yes,
think
Carol.
Jocelyn has picked up a few questions. Jocelyn,
Thank you, yes. Are they
you
on
wanna post
WhatsApp
them?
to me?
Hi,
Or you're going to
Nicole.
post them?
I
Hi.
thought you'd go through before we go, because this question I think may have been based on something you said earlier. So it's Grace from Digital Springboard, and she'd like to know, will the naming, whether it's through the registrar or versus the directorate, will it create another tier for NPOs to be recognized as credible?
So sorry, you're a little bit faint. I don't know if everybody else can hear you.
Okay, once again, I forgot to put the mic by my mouth. Sorry about that. Grace from Digital Springboard asks, will the naming, registrar versus directorate, create another tier for NPOs to be recognized as credible?
Okay, so I'm going to answer according to my understanding of what's intended. So I think the idea, the background that I've been given, and people have various views, is no, it's not about another tier. It's about renaming the existing structures, and the intention is for that to be able to move out from under DSD. And so apparently those names mean that it is a kind of a minor department inside of DSD, which according to them means that they don't get enough funding and they don't have enough capacity to do the work they do. So it's a politically based and a structurally based thing about calling yourself something different so that you can have a different, so that the entire, what is now the directorate, which they want to be called the registry, will have a different status and perhaps be able to be in a different context. But no, it's not about adding, there won't be a directorate and a registrar. It's about renaming the same things. Does that make sense?
I'll leave that for Grace or anyone else to actually let you know if it makes sense. And while we wait for any feedback from them, the next question is, when is the last date for submissions?
So the last date for submissions technically was last year sometime. I lose track, but the process, as far as I understand it now, is that that the directorate has said that they are still open for submissions. So although there was a date that was set that we were meant to have submissions in by, because the notice went out really late, and in fact the memo explaining the act went out really late, and I just think the memo explaining the act didn't explain much also. So I think that so they are currently, if you want to send to the same email address as your submissions and you want to do it now, go ahead. I think that after the next engagement that we have with them, they will and they must, because there's things that we need clarity on in order to be able to say yes or no, right? And I think that some of that clarity is yet to arrive. So I think there certainly will be another opportunity. They've given an undertaking. There will be another opportunity for people to make submissions. If anybody disagrees with my summary or understanding, please, Farrell or Glenn or anybody, let me know. But that's my understanding of how it's rolling.
Okay, I have another
No.
question for you. Sorry, go ahead, Glenn. After.
No, I'm just confirming what Nicole is saying. I think they've allowed the process to continue, but we will have I think, more clarity and definitive deadlines once there's this consultation. So there's still space, essentially.
And just a last question for you, Nicole, before you go ahead. Does registrar mean more of a regulator than a secretariat?
So yeah, once again, these are things that we don't, from my conversations with people inside the directorate, the answer that isn't, I don't think that that's what they're intending. That's not what they're saying they're intending. I think they think it's about a kind of a move perhaps outside of DSD, or else a status move that'll allow them to access more funding and capacity. It shouldn't be, so the act, look, the act will be the act. And I think that if some of these amendments go through that are putting kind of generic words in, like prescribed, instead of saying what we must do, then we can expect there to be, I think, a fresh batch of regulations coming out giving the detail underpinning those. But there shouldn't be more regulatory stuff going on. No, I don't think so. I think there would be a huge political kickback against that.
Thanks, Nicole. No more questions. You can go ahead.
Okay. All right. So I'm just trying to get to the bottom of this. And I mean, maybe there will be a whole lot of general questions that, and I'm sorry if I'm scrolling past anything that's particularly close to your heart, because it's kind of light. If you see, some of these ones have got only 1 or 2 people, and they're kind of, although they're legal, some of them are technical. Some of the things are, for instance, I mean, the introduction to the bill talks about a sort of an arbitration tribunal. There's been talk around an ombuds, but then of course there's nothing in the bill that actually deals with that or sets that up. But I think those are then things that are for policy and for bigger decisions. And then in terms of this one, which is around the category on governance of nonprofits, the 2 major things, I think I need to make this bigger for you. Sorry, let me just do that quickly. Yes.
Nicole, after this, I don't know if you want to take a comment from Malusi, or you want to do that after you do this.
No, go ahead, Malusi. What did Malusi have to?
Thank you, Nicole.
Hi.
I just wanted to find out whether the at the moment the requirement is for an audit review or a full audit for the NPOs. What is currently in the current arrangement in terms of the present act, and whether there's going to be a deviation from that, whether they want to move to a full audit for the NPOs. Thank you.
Okay, so that's an easy one to answer. Thank you for that. So the current standard is not in fact audit. The current standard is independent review. In other words, an accountant who is a qualified registered accountant, not necessarily a chartered accountant, and who wasn't involved in the preparation of the books and the financial documents, conducts an independent review. In other words, looks at the document, looks at the financial statements without going through an audit process, and signs off on it. And that person needs to have a registered accounting practice number for that to be acceptable. So as I understand it, there are a whole lot of nonprofits that don't have the finances or the capacity to meet that standard. There are also some technical amendments in that some of the Act refers to kind of outdated accounting standards and a statement, and that's the accountants in the room will be able to answer that, and it's around GARP and IFRS for SMMEs and all that sort of thing. But as I understand it, the idea is that there'll be regulation issued which will then say, much like the Companies Act does, and to me they should follow those sorts of standards, or in fact the easiest thing would be actually to piggyback on that standard. But I think they're intending to add another lower layer at which, I don't know, perhaps internally compiled documents, financials, records of nonprofits would be acceptable if the turnover, if the income of the nonprofit, I'm just guessing because there are no details, but there does seem to be an intention that there would be, it's not so much about raising it as creating it in different strata depending on ability, capacity, and income, and that they want. So there are a lot of nonprofits who haven't been non-compliant for a lot of years, and if they were to clean up the NPO register at the moment, I think the concern is they would lose a whole lot of nonprofits that cannot comply with that independent financial review standard because they don't have the understanding, the capacity, the funds to be able to do even that. Does that make sense? Malusi, I think I've answered you there.
Very well. Thank you, Nicole.
Yeah. Okay.
Nicole,
Yes. Hi,
we
Jocelyn.
have someone that's asking a very specific question and advice about old and updated constitutions. Do you want to address it now, or should we send it to you later for specific answers to that particular?
I think maybe just send that through to me, Jocelyn. I think,
Okay.
yeah.
Celestine, I hope you're
particularly
okay
deal
with that.
No worries. Just
Okay.
email it through to me or send it to me. That's
Will
fine.
do.
Connect us. Okay. Okay. So anything else on the legal or anything else that I've maybe flipped too fast past? I don't want you all falling asleep, but I do want you to kind of. So this page that I'm on at the moment is around what I've just called the governance ones, and so one of them, this top one, is around specifying. So at the moment, the Act just prescribes that the Constitution, or the founding document, as I'd rather have it called, the founding document must specify organization structures and mechanisms for governance. They've added words here in the bill which say at its minimum include the office of or designation of secretary, chairperson, secretary, and treasurer with their deputies. So there were 9 submissions made on this, 7 opposing. And I mean, I just think some of it's around clumsy drafting, and that effectively, if you do the maths there, then you need 6 people on the board. A lot of organizations don't have 6. A lot of the comments were like, well, if SARS is happy with 3, and if the companies, NPCs, are happy with 3, why is it suddenly being more burdensome at the NPO end, where it's meant to be an enabling and supportive place to be, as opposed to increased burden? So there've been a lot of submissions on that. I think they're going to have to dial it back, just because, and I think they made a mistake in the way that they drafted it. Are there any comments on that particularly, or yeah? So I mean, I have actually sent this colorized summary through to the NPO directorate, so they should be able to see the flashing orange ones too, that people are definitely opposing. This embezzlement clause, so they've said that this is again an oddly drafted. They've actually said that the founding document, the Constitution as they have it now, the organization must disclose whether a member or office bearer has previously been found guilty of an offence relating to embezzlement of money. Of course, it would be impossible for that. I mean, it would, that's an ongoing factual thing, whether that has occurred. So it's a bit of clumsy drafting. It must go, if they want to put provisions like that in place. And then there have been, as you can see, a whole lot of people opposing or suggestions. One of the suggestions was, again, the Companies Act already has a very clearly defined kind of thing for people who can't be directors. Those same standards should be referred to and applied. And also that it should be an ongoing requirement. So that, why just embezzlement? Some of the comments were made. There should be bigger words, other words. Anyway, so, I mean, this is just a very brief dive into some of the kind of pain points in it. But I hope it's giving you a sense of the level of the document that was put out, some of the things that people are or are not. So, I mean, this, for instance, is all of the submissions. And then if I just scroll through them, you'll be able to see the kind of extent of people saying, well, what ifs, no, yes, we really, really don't like that, on the whole lot. I think I'm just gonna, unless there's anything else, I'm gonna stop my share on that so we can all see each other again. Okay, are there any other burning comments coming through, issues?
Nothing at the moment, Nicole.
Nothing at the moment. Okay, all right. Farrell, I think Is there anything you want me to cover, or Glenn, is there anything I've skipped over too fast that I should go back to, perhaps?
Hi, Nicole, there's a raised hand. Malusi Vacha, Talte Environmental Center.
I think Malusi's hand was up before. Is that still an up hand or a new hand, Malusi?
Looks like a legacy hand.
A legacy hand.
All right.
Like that. Okay.
Okay, unless there is something else, Malusi, you maybe just want to put it in the chat. Then Justin can feed that into the session.
Thanks.
Nicole, I think that was very detailed and very robust and a lot of information. And I really think we should thank you for the hard work that you and your team have put in to collate first of all, collate and then to share it. And of course, most of the people, I hope, have read it in the email that was sent yesterday. There was a reminder email, and you would have seen there's a link to an Excel version of what Nicole has presented. So you're most welcome to look at it in a little bit more detail in your own time. All right, so thanks very much. So our next presentation was going to be William, but I don't think William has arrived yet, unless I'm not seeing properly. Bayanda, has William arrived? No?
Okay.
Not yet.
I'm seeing a comment here from Betty Nevert. Shall I just answer that while I'm seeing it come through? So yeah, so Betty, I mean, it'll depend which of the amendments go through, right? So I mean, I think we're looking at a process here, and Farrell, please correct me if I'm wrong, where we're hoping that in the next engagement we have with the directorate, they give us some indication of, okay, you're right on these ones, they're actually big policy things that require more consultation, we're pulling them out. Or, okay, whoopsie, we made a big mistake with that one, we didn't realize the Companies Act already dealt with foreign organizations. Or, okay, these are the ones that everybody's green on and happy with, and this will go through. And so I think we're expecting there to be a modified NPO bill that's dialed back and has the things that everybody's going to support, that maybe goes. I think that's the intention.
Right.
And then I think hopefully those things that would be like, so for instance, the name thing, that would be a big thing. If they push that through, then there'd be a whole lot of organizations would be, we immediately don't comply. I mean, that would be a major issue. But yeah. So there shouldn't be an impact on already registered nonprofits. Yeah, sorry, Glenn's answering, I think, too.
Sure.
Thanks.
Glenn, would you like to go ahead?
No, I'm not answering. I think Nicole's answering.
Okay, you had a hand up.
I had a hand up.
Okay, so you don't disagree. I said it all right.
No.
Okay.
Nicole, I have a question which might be strange. Considering, and this is, I suppose, the bigger concern, the underlying concern that many of us have. The effect of these amendments, in your assessment, does it qualitatively, even, let's just say, so the current amendments as they stand, will they qualitatively enhance the intended services which the NPO directed are supposed to deliver to nonprofits? And so that's part one of the question. Part two, do these amendments in any significant way strengthen the enabling environment for nonprofits? Just I know it's a high level question, but it's just sort of at that level. What is your take?
So my take is that, and I think that there's good intent behind some of it, and some of it's just clumsily expressed. But in terms of enhancing and supporting the nonprofit sector, I think that the idea of introducing levels of compliance as opposed to a one size fits all, that certainly is something where they're looking at enabling and supporting and enhancing their ability to support the nonprofit sector as a whole. And I don't think anybody's disagreeing with that. It's just that we would like visibility perhaps of what those layers would look like and what the requirements would be in them. And then just in terms of kind of the renaming things, what we call, I've kind of called the kind of political things. I'm not inside of government, and I've heard in this room and others various views on whether that will impact. So certainly there are people at the NPO Directorate who think that calling themselves something different will enable a transition, and that will enable them to access bigger funding and build more capacity. Because if there's anything that has become glaringly apparent through the whole of this process to everybody, it is that the capacity at the NPO Directorate is extremely limited and in various ways. If you just look at what we've been offered to deal with, and so certainly more money and people with the right kind of heads are needed there. Yeah, Glenn, sorry, did I answer that correctly? Or did I answer your question?
You did, but can I have a follow-up,
Yes,
if
sure.
you don't mind? So this is a question that I think has been nagging us, and that is to say, the amendment process, is it necessary when already the minister is empowered to make regulations? So when you said they want to introduce levels of compliance, does an amendment does it empower that? Okay. And can the same outcome be achieved through regulation on the current legislation? Because the proof of the pudding is going to be in the eating or something like that. But the devil is in the detail, clearly. And the amendments currently don't enable us to understand the level of detail. So I understand if the intent is, let's not go for a one-size-fits-all regulatory framework. So we want to have levels of compliance, which are more appropriate to levels of organization of different types. How does that stack up against, I think what the department's figures suggest is that out of the database as they have it now, 90-odd% are effectively voluntary associations.
Yes.
And then a much smaller band, I think something around between 3 and 5% are non-profit companies. So those are the ones there who have that CIPC registration. So, what is the best route to achieve this, or what are the options that we should be considering ourselves?
Yeah.
Nicole, do you want to answer that and take a message from Lucy as well?
Okay, so I think I must answer that while it's in my head. Okay. So I think, look, I do think that there is something sensible in putting things in regulations because numbers change and the world changes, and you don't want to be amending the act every single time. And I'm actually just having a quick, because sometimes one needs to flick back to the actual act here. Glenn, I'm just having a quick look to see, because some of the things, I mean, the accounting, so at the moment, as it stands, so just if we look at the accounting thing, the act says, and I'm just going to see if this will let me share. So at the moment, it says this. It says every registered non-profit organization must in writing provide the director with a narrative report in the prescribed manner. So that's already, as you say, that the content and the level of the narrative report is already referred to like that. So that could be done by regulation, together with the financial statements and with the accounting officer's report as contemplated in section 17(1) and 2. So this is the bit that's specific in the act. So it's standards, and I don't know if my text is big enough for everybody to read. Generally accepted accounting practice, that seems to be something that needs to be updated. And it has in the act at the moment very specific requirements about the accounting records and reports that are required in that part of it. So that is one of the bits that they're trying to amend to say, instead of saying, okay, this is the detail, they're saying, let's put that in like the rest of the narrative, let's put that in the prescribed manner. So, yeah, and so I don't know, Glenn, did that answer you? Did that answer everything you were referring to? That's just one example.
Yeah, no, that's fine. Thanks, Nicole. We can pick it up further.
Yeah. Okay. I don't know if
There's a
there's anything.
question.
Sorry,
There's a question.
go for it.
There's a hand from Lucy. Not asking the question anymore.
Hi.
I'm Lucy.
Hi. Sorry, I think it was a legacy question, but a hand. But let me just ask, because I have got this opportunity to comment. It was going to be a comment on the declaration by the directors on the whether the directors have got criminal record or not. Already in the Central Treasury Systems database, you do need to make that declaration. So in terms of that requirement, as well as what is currently being expected from the National Treasury, especially if you are going to receive money from government, if you are a director of another entity and through that directorship, your tax liabilities are not up to scratch, they then pick it up and it becomes non-compliance.
Yeah.
So basically what they trying to do, they linking up SARS, CIPC, Treasury, so that if you default from one entity, you cannot resurface in a different entity and want to do work with government. And I think it's not just a government requirement, even private donors want to know if any of the directors have actually a criminal record, because it does have implications on whether to provide funding to the entity or not. Thank you.
Thanks, Lucy. And in fact, so in various parts of the comments that are made on the bill, it's just, there are often things that are in place that can be used instead of trying to reinvent the wheel here. As you've said, I think that one thing that we need to bear in mind when we talk about the NPO sector as a whole is we're not only talking about nonprofits that are getting money from government. We're talking about people making, people calling for donations to the general public, and whether there's credibility in their checks there. So, as you said, though, if there are already things in place and we can just link into existing systems, then yeah, that would be more useful. Glenn, how's it?
Sorry, Nicole, a last less than useful question for you is, how does this interact with the Lotteries Act?
With the
National Lotteries Act. How do these amendments align to any other legislation that is currently in play?
I would be answering off the cuff because I haven't looked at the National Lotteries Act in that kind of context, but my guess is probably not at all. I mean, if these amendments didn't look at any other sorts of legislation, I very much doubt they looked at that. I mean, if anybody would like to join me in a ploy to have the National Lotteries Act amended next, I think we could create some, but one thing at a time, probably. And chief amendment to that would be that whoever runs the National Lottery has to be a non-profit. That would be the basic requirement to any amendment, in my view. Yeah.
Nicole, Anne has a hand up.
Hi, Anne. You there, Anne? Or are you muted? I can't hear.
She's still muted.
I'm now
There you
unmuted.
are.
There I am. If I recall back to the very early days of the Lotteries Act, the whole concept initially was that you had to have an NPO number in order to apply for lottery funding.
Yeah, and that's still there as far as I know.
But at that time, the NPO Secretariat, as it was called then, was way behind with the registrations, and the sector was getting very frustrated because NPO numbers hadn't been issued and they were ready to apply for funding. And that, with the two talking to each other, the two systems, it suddenly sort of it disintegrated and stopped talking to one another, which is quite sad, because had that worked, we would have had a better view of how the sector is progressing today.
Absolutely.
Yeah. Anyway, that
And
was just a bit of
yeah.
background there.
Thanks, Anne. And I know you've been around long enough to see a whole lot of this, and also you seem to remember a lot of it, which is amazing. So the same thing happened with SARS, if anybody remembers. So the first iterations of the PBO legislation, which came in the year 2000, it was a prerequisite that you had to have NPO status. And at that time, as you say, and I know because I was making NPO applications at the time, it would take over 2 years to get an NPO number. And at some stage, I think in about 2004, so I'm just guessing, SARS washed their hands of it because it was just holding up them too much, and they removed that. I still have a lot of people who think that you need an NPO number in order to get PBO status, and then a lot of people who, when they discover that, actually think, well, let's ditch the NPO number, it's not worth. And that's the sentiment at the moment. I'm more and more finding people saying, why must I have this thing? Some Google AdWords for free, some accounting packages for free. We can get money from lotteries, and that's kind of the list at the moment. Sadly.
Yeah. Thank you.
Thanks, Anne. Useful.
No more questions from me, Nicole, at the moment.
Okay, thanks.
Thanks, Nicole. Are you able to take a breather now? We'll let you take a breather.
Yes,
it's been a really lovely session.
I must turn my aircon on, I think.
It's been good. It's been very interesting, and I'm very thankful for the kind of questions that have been posed, because, you know, we're all learning, and of course, one person's question is certainly 10 others' answer. They can take it away and factor it into their own kind of question or challenges and concerns that they may have. And often we don't know how to phrase our question, but others are actually helping us. So that's really great. But again, Nicole, you've done this amazing work. And I know I said thank you already before you went on another round. You and your team have done an amazing job in compiling this. We did get a few questions from some people who have asked if we are able to share what you've presented today. And so I leave that to you to tell us, because if it does, if you agree, then it will obviously be posted on the website.
No problem. I thought that already was the one that went out, the colorized version. I mean, the submissions that have been made, and maybe we must just put a little disclaimer on it or something. I'm looking across the person to say these are NGO law summaries, and if we've got it any of it wrong, let us know, people. But yeah, so we just tried to create something that was useful and gave us a better visibility of what was being proposed. Of course, people, when you look at these amendments, you do need to do what I did just now with Glenn's question and flashback to the actual act. And say, okay, look at that, and you have to look at them in context to be able to understand it. That's a crucial thing to be doing.
Okay. Okay. Well, that's great. Well, thank you for your generosity, Nicole. So I'm going to, unfortunately, William hasn't arrived yet. So we will go and proceed to Suzanne, who will give us just a little bit of context around the nomination. Suzanne, if you can also just provide some context with regards to why we're running this process. Bill, both Glenn and myself, and perhaps Nicole did as well, alluded to a potential meeting with DSD either later this month. And so the nomination process that you're going to be talking about is in relation to that. So I'm going to hand over to you. Yes.
Ferial, I don't know if Suzanne still wants to go, but William has joined us. So he may. Okay.
All right. Right. So let's in the order, if you don't mind. Suzanne, I'm really sorry. Do you mind if we just, William, are you there? Can you give us a hands up that you're there and ready to talk? Bayanda, are you sorting out William's access?
Good, I'm there. Haha.
Hello.
Excellent. Good morning, everyone. So sorry, I'm so late.
Hi. Thanks, William.
Right. So it's not a sexy presentation by any means, but it is the core issue that we want to speak to for the bill that really does put it in a very worrying light. Is the one around registration of NPOs. And when we generally see that coming up as an issue around the world, and certainly on our continent, it's used not as a mechanism to encourage and support the sector or facilitate other things, more credible entities. It's used almost always as a means of seeking to restrict and limit particular voices, views, and ideas. And in fact, it's something that when we started doing some research on this with our lawyers, that they found that obviously this is not, in fact, in line with international law. It's not in line with the special rapporteur's views on freedom of expression. And so they talk about shifting and the critical importance of shifting from this idea of registration to a notification process and procedure that has to be easy so that you don't start to limit the abilities of NPOs to participate and engage in their right to freedom of association. So from there, we move to a position of looking at how this idea of mandatory or compulsory registration, whether they're foreign or domestic, is ultimately an unreasonable limitation on the right to freedom of association. And in fact, we would argue quite clearly and unambiguously that that's an unreasonable limitation under our constitution. So not only is this not merely an administrative change, we believe it's one that would that would make the amendment bill fundamentally unconstitutional. And that, for that reason alone, whatever path the DSD chooses to go, whether it's this a little bill that makes certain changes and then the full-on policy process and proper amendment process, which I think is what we've been calling for, whichever direction they go, this idea of mandatory registration it's essential that we fight that and challenge that. And if we don't, then I guess we just need to make the DSD alive to the fact that they'll be facing a constitutional court challenge from us. That's pretty much all I wanted to add. I hope that's useful. Over.
William, thank you very much. I think it was very useful. I want to ask if anyone has any questions or comments in relation to what William has just shared with us. Please feel free to. We've got a bit of time in order to do that. So I'd like to open it up. Glenn has his hand up. Over to you, Glenn.
Hi, William. Thanks for joining us. I know you occupied elsewhere. Can I just understand clearly what you're saying? You've got a sort of legal opinion that suggests that if they pursue the registration issue, that it is best to block that in its entirety, that it's not something that needs to be entertained or fiddled with. Can I be clear? And that we've got a strong legal foundation from which to move on that particular issue.
William, you're on mute. Bayanda, can you unmute William?
There you go. Sorry, I had to be unmuted by the powers that be. Thanks, Glenn. Sorry, and then there's a loud truck behind me. Apologies, everyone. It's not a formal legal opinion, no. We did work with our lawyers to come up with that. So it is a very well-informed legal submission that we would make as in the process. I guess we could speak to one of the advocates to see if they would be willing to give us one, but I think it's a pretty clear and unambiguous answer there that this is, I mean, it just goes against the, you know, the various resolutions. There's the special rapporteur, and then there's our own constitutional limitations around it as a means of limiting freedom of association. So, you know, I'm very confident of our position on this. But if people would like to get something more solid, I can see if one of the advocates we work with might be willing to try and pull it into a formal legal opinion. But I think that as a default, on a principle basis, it's something that we can and must and should oppose, just because of its fairly obvious limitations, because the way it's currently phrased talks about it applying to foreign NPOs, and they don't define that. I mean, it's just a dog's breakfast at the moment, and there's so many ways that it would be subject to constitutional review. I don't think that we would have any kind of challenge with that, really. Hope that is useful, Glenn. Over. I won't mute yet, just in case I have to answer another question.
No, I think that's thanks, William.
Are there any other questions from the floor? Okay, it doesn't look so. So thank
There's
you.
one from me. Sorry.
Oh. Go ahead, Jocelyn.
Mary?
Hello, yes. I'm from the Johannesburg Homelessness Network, which is registered, but I also belong, and we are members of the National Homeless Network, which has chosen not to register, which is quite interesting. We appreciate both sides of the coin, of the argument, and I understand why, you know, especially in relation to foreign NPOs. And the freedom of association, but I do feel that if one is to receive public money, that there should be some form of registration. How do you feel about that? Thank you.
Oh, I can unmute now. Sorry. Should I try and answer that? I did try in the chat.
Yes.
I think most of our organizations are currently registered. Often we've done so because of a request from some of our donors to provide your number. And I think a voluntary notification or registration, if you're going to call it that basis, is probably the way to go. Again, I completely agree that anyone receiving public funds or indeed, you know, private funds, there needs to be openness and transparency about those. And I think that we can encourage mechanisms that build that kind of thing in. But I don't think that the way to go about doing that is through registration. I don't know about you, but it doesn't seem to me in any way to have made any difference to those that have defrauded the National Lotteries Commission, which have been many, you know, legitimately registered NPOs. So that doesn't solve or deal with the problem, which isn't to say that I have an easy answer now, but that's why in the white paper, and if we do that policy process, we say, how do we tackle this challenge? How do we encourage a more open and transparent and accountable NPO sector? So I'm not for a single moment suggesting that we shouldn't be and that we shouldn't be taking even greater steps. I think that's probably one of the ways that we can and must go about making sure that there's greater transparency and to help combat those astroturfing NPOs who are clearly, you know, set up for nefarious ends. But doing it as a forced and mandatory registration, especially just for foreigners, doesn't solve a single one of those problems. It just opens a door to a living hell, or something that's like Putin's backside, I would suggest. Over.
Okay, over to Nicole, who has a hand up.
Sorry, just William, some additional bits and pieces. So I wanted to make it clear that there's often a misunderstanding. People often think that if you are, particularly if you're a voluntary association, that you have to have an NPO number in order to legally exist, and that is just not true. A voluntary association is established under common law. As soon as you all sign the Constitution, which is your agreement, you have a legal entity, and a bank who tries to tell you you have to have an NPO number needs to be told where to go in a possibly polite and maybe not so polite way. I think that sometimes because people don't understand that fundamental thing, they kind of think they're trapped by this NPO thing and that they have to have it in order to satisfy certain basic regulatory requirements, but that's not so. And it is certainly voluntary. And I mean, there are organizations, and particularly, as you say, an organization that's got a big private fund or family money funding it or whatever, there's no need for them to do the extra admin and jump through the hoops and things of NPO, paltry as they are, of NPO ongoing registration. So the other thing that I wanted to make a comment about was about the openness and transparency thing. So, I mean, there's this like an accountability. There's this fabulous idea, and that kind of lovely idea, I think, was part of the buzz of the initial NPO Act, that there would be this way that everybody would go onto the database, you'd be able to see who was registered, you'd be able to see if they filed their reports, you'd be able to see who the human bodies were behind that. And I don't know if anybody recalls the exact time and date, but it was a couple of years ago when kind of half of that disappeared off of the NPO database. And it did so for some very good reasons. And in fact, I heard a rather horrid story about somebody who was tracked down and harmed because the details of the place where she was sheltering were found on the NPO database. And so there were, I think part of the thing was that NPO database was never secure. It was hackable. You could mess with it quite easily. And then also I think they realized that the kind of privacy and confidentiality and protection of beneficiary aspects needed to be taken really seriously. And so it's this thing where you can't actually at the moment go onto the database and figure out whether anybody's filed any of their reports. You actually have to email the one person who answers their emails and say, how far is this organization behind with reports, to be able to know. So, I mean, you can't even really get that kind of information off it at the moment. So it's become a kind of a non-thing because of that. But as you said, there are no easy answers on these things, William, because there's so many competing requirements. Thanks, that's me, over.
Thank you. Glenn had his hand up.
Yeah, sorry. Just one question, I think, to Nicole and William, and it's about the anti-money laundering aspect. So I understand that there was an assessment report that was produced for the task force or whatever, this international thing, and it made specific recommendations on the NPO Act. So it's anti-money laundering and countering financing terrorism. But there's a sort of thing that has been unfolding in the background. It's obviously not been pulled through in these amendments, but do we have any clue about where that conversation is at and how that is being managed?
Glenn, I'm sorry, I can't be useful to you on that because I haven't been in any back rooms on that one. I mean, I know in some of the comments in the memorandum that was produced, there was reference to that. That was news to me that was even in anybody's head. And just trying to think through logically, I don't see how the amendments that were being proposed in the NPO Act would assist anybody in any way, especially since they weren't necessary because the Companies Act provides for it anyway. So if it's about NPOs being used to launder money and being in the country unregistered and under cover of darkness and nobody knows about them and here it's going, then there are other ways to tackle this. But it's just like nobody, you know, And once again, it's about people all understanding all the moving parts that there are and how they can and should all work together. And if the NPO directorate gets an application from a foreign organization to register as an NPO and they can see that they haven't registered with CIPC, but the people at the front line there don't know well enough to say, where's your external company reg number? Thanks, Glenn. Yeah.
Glenn, you wanted to add?
Well, I
I don't
think
know
it's
if I
just something. No, you did. Thanks. I do think that what we're stuck with is things that are not clear, and I think that's the key thing going forward is to get as much clarity as possible. But the point is, there have been these recommendations. They are in somebody's head or in some process somewhere, and where I think my concern is that even if you fix the formulations, and even if we tighten up some of these amendments, and then power shifts dramatically to the department or the minister to pass regulations. So we've got to be watching how much leeroom we are creating. We've noted that in Tanzania and Zambia, the anti-money laundering, combating terrorism angle was used quite draconianly. So it appears benign on the surface because obviously, I suppose we all have our bona fides in check here amongst ourselves. So we don't live in a world where we're financing terrorism or laundering money, generally speaking. But when that is introduced, it creates the potential for abuse. And I think we just need to be quite careful because DSD only has so much pull. The problem with the anti-money laundering, combating financing of terrorism is it sits with Treasury, which has the biggest say. And I think when we open that door, if potentially there is something that they are looking at or that is being crafted for regulation, it becomes much harder to ensure that there is fairness and balance in those sorts of regulations. So it's just something perhaps we need to have find out about.
Yeah, amen to that.
William, is there anything you wanted to add to this discussion?
Fidel, there is a hand raised.
I'm happy with that. Thanks.
All right, thank you.
Thank you.
Fidel, Betty has a hand raised.
I couldn't see that. Thank you, Jocelyn. Betty, would you like to proceed? Bayanda, you need to give a right to talk.
Can you hear me?
Yes.
Hi, everyone. I just got two things on what William also said about a white paper. There's a couple of things that is very worrying. The one is corruption within the NPO sector, how to deal with it. And when I look at the governance side on the amendment, it really speaks little about that. We have reported NPOs for many, many years, and we know that nothing has been done. And it is millions that just disappeared. So that is the one problem. The other one is that if you, every second person registered an NPO, and if you see, they say, all right, I do have now my NPO number, what is the next step? And I do agree that it must be voluntary. And I do agree that, you don't need to have an NPO registration number to do your business. This is the one thing that is very worrying in the sector, to my mind. So what are we going to do to tackle governance, accountability, and corruption? And isn't it time just then to speak to it now whilst the act is in the amendment phase? The other thing that I want to ask, and I think Farrell touched on that, why do we in the NPO sector are met with this hostility from government? Why are they not able to assist NPOs to better services or to do society better? Why is there this hostility towards us? Thank you.
Yeah, so I mean, if I can just jump in there, am I still on? Yes, I am. Just in terms of the governance question, which is a crucial, and I mean, the issue, I think, is that the wanting to encourage good governance and making sure that those who are on the NPO directorate are people who are playing the game cleanly and openly and accountability and with good ethics. And then the kind of enabling, trying to make it more kind of inclusive and voluntary, those things, there is a way in which they kind of fight against each other, and there's certainly a balance to be found there. But I do agree with you that if there's going to be value in the NPO accreditation, that there should be something around that. And at the moment, all that there really is that to get into the loop in the first place, to get that stamp, to get that certificate, you have to have those minimum good governance clauses in your founding document. But there is no actual oversight or finding out or following up on whether anybody's actually following those rules. And I routinely meet with organizations that are set up with voluntary associations who don't have any members, and so there's never been an AGM, and so they're just making things up. And those reports that go in, everybody who's filed an NPO report will know that the level of interrogation of what you submit is just procedural and tick box clicking. There's no, you could write in your narrative that you had held a jamboree and invited 1,000 naked people, and nobody would even read it. I'm just making a bizarre example. But as long as you've submitted the narrative and the financials and said how many meetings you've had, and you've got a register, and people, if you've done that, then tick, tick, tick you through. And and that again speaks to capacity, and capacity in terms of numbers of bodies, but also capacity in terms of the level of understanding that the people who are working in that sector have, and what their role is. And yeah, there's none of, I agree, very frustrating.
Thank you.
Sorry, I'm talking too much.
No, not at all. If I may, we have to do the next part of the program is to talk about the nominations. That, of course, William, if you and Nicole and Glenn have concluded the discussion, I don't think there's any more questions. Jocelyn, am I correct? Are you happy that we move on, Nicole and William?
Yep, no issues.
All right, thank you very much. So the next part of the presentation will then be Suzanne. I am going to allow you a time just to get context, and then I'll open the link for you. Is that okay?
Yes, that's fine.
Thank you.
Yeah, so Fidel, William, Nicole, and Glenn have kind of referred to this upcoming workshop with DSD, where they're hoping to give more context to the amendments that they proposed. DSD has, however, limited the amount of people who can attend to 100 people, and have asked for representatives to be nominated to join the meeting. So this meeting currently is going to be held on the 23rd of March, 50 online participants and 50 in-person participants. And the in-person participants will meet at Taylor's offices in Woodstock. Yeah, so that's, and it will be from 9 until 4. So Phil, if you can go to the form. So we've drafted a form to assist with the nominations, and we'll send that link. Beyanda, if you could send the link in the chat, so everyone can have the link to the form. Yeah, so the form is meant, yes, you can nominate someone else, or you can nominate yourself to attend the meeting, but yes, we are limited to 100. We proposing that nominations close on Tuesday, the 15th of March. That gives those who are nominated a week's notice for the meeting on the 23rd. And so just some of the sections, you'll just to give your name, the name of the nominee. Feel if you can go down. So the idea is to kind of ensure that there's broad participation from the sector at the meeting. There's only 100 people. But yeah, we're just trying to ensure broad participation from NPOs, the NPO sector. So their contact numbers, email addresses, and then just to clarify what sector they represent. So you can choose one, or you can choose more than one. Then the size of the organization, what province, what is the reach of the organization. Then We are proposing that those who attend represent a constituency. And then just need to clarify how this information from the workshop will be shared to that group of people. Speak to the nominee's experience, then speak to whether the nominee's been involved in the amendment process so far, is up to date with the developments. And then, importantly, are they able to attend the workshop on the 23rd? And will it be in person or online? So yeah, just to the outcomes for the DSD from this workshop, and maybe the working group can add to this. But DSD is wanting to, one, give context, yes, and two, to get a sense of what amendments can be made, and then what should be left for a more lengthy, detailed policy review process. Yeah, so the link will be live. It is live now. So you can nominate yourself or nominate anyone else. But Tuesday at 12 it will be closed. So please do share if you can with within your organizations, within sectors. Yeah. So that's from me, Carol.
Thank you. Thank you, Suzanne. I'm sure that some people are curious. I mean, that it's limited, right? The in-person is in Cape Town. It will more than likely be at the Inyatelo offices. That was certainly the discussion that was had the last time we met with DSD. And then, of course, we will make sure that it's a hybrid model, that we can, those who cannot join in person would obviously be joining virtually. The issue, of course, is how do you nominate? We do want to make sure that the representation is fair, that it covers all the sectors, that it covers different sized organizations, because we don't want a situation where the bigger organizations kind of hog the room and the conversation and make decisions for the smaller, medium-sized organizations. So we will be looking at that as well. The working group will make decisions around that. I certainly cannot speak for the working group, but if any of the members of the working group have a comment about that, you are most welcome to pose that comment now.
Thanks, Fidel and Suzanne. I think the most important thing I want to convey that we should be clear about is that this meeting is being convened and coordinated by the Department of Social Development. So it's entirely their meeting. We, and I'm now saying we, in particular, Inyatelo, on behalf of the working group, is creating an interface to broaden participation and to assist as many organizations to participate in one way or another. It's been done by National Department of Social Development, and they will also invite who they wish to invite. So we are facilitating as many people's participation as we can, but it is not a meeting of the working group. It's not our meeting, if I can put it like that. It's DSD's meeting. So there are limitations. And unfortunately, I think Fidel, despite Inyatelo's best efforts, you guys are simply the hosting space to encourage them to sort of bring people together. Yeah, but it's not an Inyatelo meeting. So I think it's very important. This is a meeting which has been put on the table by the department, and we don't have sight of the agenda. We don't have sight of a lot of the back end stuff, the preparatory documents and so on. But we are attempting as best as possible to encourage participation. And this is one of those things that we think can help. So this is not intended to preclude people. It wants people who are invested and also this diversity of opinion and experience to be in the room, well, in the room, so to speak, when these conversations are taking place. So I think that's important, just to not, for there not to be a misunderstanding. Even though the venue for the in-person meeting is in Inyatelo, the meeting is still.
I want to underscore absolutely what Glenn had just said. it's, as I said, the discussion was around potentially using the Inyatelo venue, but it could be, it could turn out to be any other venue for that matter. But you're right, Glenn, we're simply trying to make sure that the meeting happens, but it's not our meeting. It is a DSD's meeting. They will drive everything from the agenda to, participants, etc., which they will bring on board. We're of course making sure that the sector knows about the meeting, and should it come to the time where you are being asked, where the invitation goes out, at least you're aware of it already and thinking about it and thinking who you want to nominate, whether it's yourself or someone else to attend, but basically just to communicate and expand the knowledge of a potential meeting that is coming up for the purpose as described there on the screen. So if there's no other questions, we're coming up to 11:45. Ideally, we
Sorry,
would like
Fidel.
Yes, Justin, go ahead.
You're doing only one sentence. Just a quick question from Margaret, I think it is. Does the form allow for an organization that is a networking organization made up of many national, provincial, and local organizations as members?
Suzanne, can you respond to that?
I think it does.
Yes, yeah. And I think
Yeah.
it would come under the question about reach. So whether it's national, provincial, and local, your reach would then be national. But yeah, so, and all the organizations you would then link to say, these are the different sectors that this network then.
So you'll see as question 9, there it is. What is the reach of the organization? And you can choose. Okay.
Thank you.
Thanks for the question. Anything else there, Jocelyn? Any other hands, questions, comments?
We all good for now?
Thank you. All right, then I'm going to hand over to Glenn Farrett now. Glenn will take the final Q&A and then wrap up. Thanks, Glenn.
Colleagues, I hope there was a complaint earlier that you couldn't hear me. I hope the sound is better now. So could we just ask by show of hands or from the chat, are there any general questions or comments that we want to make or that we would like to table at this time? Anything that is unclear, or whether there's questions of clarity or whether there are comments that you wish to share with the rest of us? I think we want to open the floor, and it would be useful if there are hands that we could see.
Glenn, Anne has a hand raised.
Okay, I'm not sure why I can't see that. Anne, go ahead. Anne, can Anne be unmuted?
Oh, there we go. Glenn, one of the things that keeps coming up is this registrar story. One of the questions we need to have clarity on, will this be a new entity per se, or will it be just a different name? Because a lot of us feel, and we felt this right from the very beginning, not at the beginning of these amendments, but 20 years ago, that it should be an independent body and not buried in one of the government departments. The biggest problem with the DSD is they have too much on their plate, too many serious social issues to cope with. And the NPO directorate just gets the, whatever's left over, we might come round to you. That's why things are taking so long of going through the process. Should we push at that meeting for that registrar to become an independent body from any government department, obviously funded by government, but independent in as much as it manages its own budget and its own team?
And I think that's you've gotten to the heart of the matter. So the engagement with DSD is, I think there is an understanding, there is a sensitization around the need for an overall of the architecture that this act is attempting to give effect to. So many people have concrete and evidence-based. So thankfully, since the Swilling study, way back on the size and scope. In the recent period, there have been some good research that has been produced. One of those reports from Kagiso Trust on the typology of the NPO sector, and many others that are beginning to suggest that an overall is what is necessary, a root and branch approach. So rather than cosmetic amendments to the Act, an entirely new architecture needs to be put in place, which takes care of the interface with these multiple legislative and accounting requirements. So, you know, CIPC, et cetera, et cetera. So how do we create a smooth, seamless framework for NPOs that is genuinely enabling, rather than changing the name of the directorate to turn it into a registrar, then going through a process of consulting on the regulations which will regulate the registrar, et cetera, et cetera. Is it not worthwhile to pause this process and put the evidence on the table and design a new architecture, what people I think commonly refer to as the NPO policy framework, and then construct legislation after that? So that is one of the things that I think is on the table with DSD in this meeting on the 23rd. So we want to hear both the logic for the particular amendments, but also what is your understanding of the broader process that you are undertaking? Do these amendments, they don't obviously meet the requirements of the sector? Are they fit for purpose? We started here this conversation at that point. That question remains on the table. Are there amendments that can be made that can ease the administration of NPOs as a short-term gap, and then you have a parallel process of creating this root and branch new architecture? Or so I think there are lots of things to consider, which are, I think, of concern. One consideration we must take is that if no movement is made to improve the legislation and the administration of that legislation, things will get worse. But on the other hand, the consideration is passing inadequate legislation can amplify the problem, can cement the problem, and then making fundamental changes become much more difficult down the line. And we are dealing here with a legislative process, so it's not at our choosing as to when and how these things happen. So I think these are things that we need to all apply our minds to. I don't think there's a simple answer, but I think in our collective wisdom and experience, we may be able to put something which is meaningful, impactful, lasting, and most importantly, fit for purpose on the table, or at least have a process that can achieve that. Thanks, Anne.
Thank you.
Do you want to come back on that?
No, you've answered it. Good one. Thank you.
Okay, colleagues, I'm not entirely able to see all hands, so if you can assist.
Justin will do that for you, Glenn.
Okay, thank you. I see Betty is very strong on the independent institution.
I was going to say there are no hands raised, but there is something from Betty in the Q&A. Would you like me to read it out, or?
Please go for it.
From Betty about the registrar, it must be an independent institution like other companies, like the Companies Act. So many NPOs fall completely outside the sphere of the goals and objectives of DSD.
Yes, I think, Betty, that is certainly one of the issues that need addressing going forward. What is the extent of the independence that is required? Is DSD the appropriate place to be the line ministry to manage this? What are the motivations? I think we've all experienced this. People are registering for completely wrong reasons, if I can put it like that, in inverted commas. But so the overall appropriateness of what we're doing and the need to safeguard the independence, I think partly what William has raised, which I think is really important, is that we must remember that the independence of the sector must be protected, and encroachment into that is going to be a very, very slippery slope. So our primary principal consideration is, how do we make the legislation fit for purpose and ensure accountability. So where is the space? What is the thinking that we have as nonprofits to ensure self-regulation, self-accountability? How does that link into legislative and other accountability mechanisms? And how does that line up with the necessary independence from the state, which can abuse its powers? I think we must be aware that even now, I saw someone in the chat speak about being deregistered. Now, this is something that the department is clearly undertaking. What are the implications of that going forward? Colleagues, are there any comments or questions? Nicole, William, Fidel?
Nothing from me, Glenn. Can you start wrapping up?
Okay. Nicole?
Yeah, no, I just thought you wanted an answer on the dereg thing. And then they had a big plan to do that, but they haven't begun it yet. We haven't seen any, and it's because of this now. They've stalled it. Have you seen anybody being deregged? I haven't.
There's a comment about someone being deregistered in the chat I saw earlier on.
Oh, okay.
But I also heard rumblings, and well, not more than rumblings, pretty strong language coming out of DSD.
Yes.
On with a time frame of
they issued that. They issued that. So they've done a couple of iterations of that, but they issued time frames. I think early last year. It was meant to all start mid last year, and then or maybe even the year. I don't know. The years slipped by. But there were time frames issued, but as far as I'm aware, none of those has been implemented yet, and it's all on pause waiting for this bill because of the compliance requirements.
I think we must take, sometimes we need to take them at their word. I get the sense that there's a deadline and they're going to start fast tracking deregistrations, which may or may not, it actually is not dependent on this bill. By the way, so I think
no, it's not. They absolutely could. They could do it. Yeah, it's not dependent on the bill, but as far as I understand, they had themselves paused it because they wanted these modifications to go through so that they wouldn't have to deregister a whole lot of people, or they would give people a chance to catch up, but at a different level. Anyway, we've discussed this. Okay.
Thanks, Nicole. Thanks. I thought, Malusi, you wanted to come. Malusi? Malusi? Did I misunderstand?
Thank you, sir. I just wanted to comment quickly on deregistration from my experience. It's a fairly quick process that they do behind the scenes, and they don't consult once there is non-compliance on any of the regulations. They start with deregistration. I mean, we have caught the process ourselves, discovered that they had started the process of deregistration. So it's people must just look out and check that they are up to date with the required compliance registration issues. Otherwise, they do start the process to deregister without consulting you.
So, colleagues, if you can all just be aware, there's the DSD calls it a campaign. It's unfortunately named Know Your Status. Just go online and check and make sure what your status is. So that you catch it. Don't just assume that you're not being deregistered as we sit here. Can I
agree? Absolutely. Yeah, and that is what we're saying to everybody. Just catch up. Because everybody's been lulled into complacency because they hadn't deregistered for so long. So that's why everybody needs to get themselves shipshape.
Colleagues, I think,
Glenn and Nicole, there's a question from Shireen in the chat. Some of us NPOs receive funding from DSD. If we separate, do you think it will have a negative effect and they may stop the subsidy? Oh, but Anne has answered the question as well.
So no. I mean, that's not on the cards at the moment. and B, the functioning of receiving subsidies, I would imagine in any rational world would not be, it makes nary a difference even at the moment. So separating the function of NPO regulation and DSD subsidies could not result in some adverse impact on the subsidy, because you have to comply with the criteria for the subsidy anyway, more than just NPO registration, if I understand it correctly. There's an entire compliance framework for you to receive your subsidy and for you to continue to receive your subsidy. Does that? Nicole, do you want to come in on this?
I agree, Glenn. Yeah, I can't imagine. I mean, that would just be bonkers.
Okay, guys, we have to
the,
close up.
Okay.
I'm mindful that we've already had about 15 people drop, which obviously just a signal that, you know, everyone's time is seemingly up. Betty, I'm afraid we're going to have to hold you over until the next time. Glenn, are you okay? You have concluded what you wanted to say?
Thank you.
Are you good? All right. Well, thank you very much. I think all that's left for us now to do is just to thank everyone. And so I want to say thank you, Bayadanki, Siyabonga, Ndiabulela, and Shukran to those who have made the time to attend, but also to the speakers. You know, you've presented, you've been thoughtful and insightful, and you've certainly presented quite a lot of information today to whoever participated. And we will make the information or the video available on the website post this event, of course, together with some more information about the nomination process. And to the participants, you have been participative. You have really played your role today. You have really made it an exciting 2-hour session. There's going to be, this is not the last session. We will continue to engage with you and keep you informed as representing, now I'm speaking on behalf of Inyatelo, who is a representative of the working group. So it is the work of the working group. This is not Inyatelo's work alone. This is the very generous working group who give their time to comment and structure and create the material that we're able to present to you today. So that's all I want to say. Just thank you. And until we meet again, go well.
Go well.
Thank you.
Thanks all. Bye.
Thank you, everybody. Bye-bye.
Bye, William.
Cheers. Bye.
Bye.
Cheers. Nice to see you. Bye.
Good. Bye, Nicole. Thanks.